Good afternoon, everyone. Thank you to everyone who is spending lunch with us today. And just as a reminder, feel free to eat your lunch since we are during the lunch hour during the program today. No problem there at all. My name is Jackie Congedo. I'm the director of the Jewish Community Relations Council, which is the public affairs arm of the Jewish Federation of Cincinnati. And I'd like to give a special thank you to Addith Israel Congregation for their partnership on this timely event this afternoon. Before we get started, I want to go through a few housekeeping items. We are presenting this Zoom event in webinar format, so you will not be able to see other attendees, but you should be able to see, of course, our presenters. After we hear from our guest, we will open it up for questions, which you can easily submit via the Q&A function at the bottom of your screen. I will then position the questions to our speaker at the end of her presentation. We are very excited to continue this year's JCRC program series entitled To Bigotry No Sanction, Jewish Perspectives at the Crossroads of American Democracy, with an important conversation about the changing dynamics of the U.S. Supreme Court. And we couldn't be luckier to have a true expert here to guide us in this discussion this afternoon. But before I introduce our guest speaker, I want to begin with a bit of context about our JCRC programming focus this year. Over the centuries, because of our nation's sacred promise of religious freedom and opportunity, millions of people have fled persecution in other countries to be part of what we call the American experiment. Soon after his election, President George Washington affirmed his commitment to religious freedom in a series of letters and speeches to religious minorities. The best known is perhaps his address to the Hebrew congregation in Newport, Rhode Island, where he said, quote, "For happily the government of the United States, which gives to bigotry no sanction, to persecution no assistance, requires that only they who live under its protection should demean themselves as good citizens." Washington's words outline an important relationship between civic engagement and a safe and free America. The promises of our founding fathers are only as good as our informed participation and engagement in the institutions of our democratic system of government. The recent rise of extremism and anti-Semitism and other forms of bigotry have created an environment where our democracy faces unprecedented threats and challenges. Our safety and security as a Jewish community is inextricably tied not only to the security of our neighbors, but also to the strength of our democratic traditions and institutions. So we designed this speaker series in order to illuminate the dynamics at play in this current moment, and perhaps more importantly, to help educate about what everyday citizens can do to strengthen our democracy, which gives, quote, to bigotry no sanction. In keeping with our focus on strengthening our democracy and combating extremism, alongside the speaker series, the JCRC is launching the Leaders in Light Institute, which is a first of its kind leadership program to combat anti-Semitism, extremism, and hatred, and to inspire community change. We welcome you to learn more by visiting the URL there on your screen, www.leadersinlightinstitute.org. And now, without further ado, I would love to introduce our guest. Ronna Greff Schneider is a professor of law at UC Law School. She is an expert in constitutional law with a focus on the First Amendment and education law. She is a frequent speaker and commentator on issues involving constitutional law, education law, and educational policy. And she's also the author of several texts, Education Law, First Amendment, Due Process, and Discrimination Litigation, and its annual supplements. Professor Schneider is also the co-editor of Education Law Stories. She has published law review articles and a book chapter on topics that include sexual harassment, hate speech, and religion in schools. Professor Schneider is an elected member of the American Law Institute. She is also an affiliated faculty member of University of Cincinnati's Department of Women's, Gender, and Sexuality Studies. She has been actively involved in the Association of American Law Schools section on law and education, having served as its chairperson and as a member of its executive committee. And last, but certainly not least, I have had the immense privilege of working with Professor Schneider in her tenure as the board president of our own Jewish Community Relations Council, which her tenure is rounding out here in June. And we hope that all of you will join us for our annual meeting where we will get to bid her farewell, although she's luckily not going so far. So at this time, without further ado, I would love to turn it over to Professor Schneider to begin.
Thank you, Jackie, for that very sweet introduction. So good afternoon to all of you. It's a pleasure to be here and discuss with you some very important topics. In fact, what I'm going to try to do is condense into 40 minutes what I've been studying for 40 years. So it'll be a little bit of a challenge probably for both of us, or all of us, I should say. Okay, now in doing that, I want to set up first that we're going to have questions after that. That's the reason for the time limitation. The other thing that I want to say up front is that my 40 minutes of fame here is going to be divided into, keeping with the 4 topic here, 4 parts. And I want to tell you what they are to kind of give you a roadmap, if you will. The first part is going to be about how the court works. We're going to just talk about how that happens and what it does. The second part is going to ask the question, after we've looked at how it works, is it not working the way we want it to, and should we change its structure? And that'll be a question of looking at, if yes, then how. The third question that we're going to look at is some specific cases, both ones that have been decided, but also particularly ones that are before the court, and try to kind of see what it means to have these 3 new appointees from President Trump. And that last but not least, I'm going to give you a brilliant and insightful conclusion. Now, having said that, let's get started. So let's do a little history lesson. The date is February 24th, 1803, and the 4th Chief Justice of the United States Supreme Court, his name is John Marshall, is going to issue a unanimous decision, but will probably be the most famous and arguably the most powerful decision ever issued from the United States Supreme Court. What is it? He said that the Supreme Court has the power of judicial review. Now, what that means is that he claimed for the authority of the court the right to determine whether or not actions of the executive or the legislature are within the bounds, within the requirements of the Constitution. That means he's saved the best for the Supreme Court. The Supreme Court, an unelected body, is going to will have basically veto power over the 2 elected parts of the government, that is the executive body and the legislature. That doctrine that he announced is called judicial review, and it has gone unchallenged, and it exists today in the same way it existed in 1803. So one might ask the question, since it is in essence an unreviewable power, that means that once the Supreme Court makes a decision that actions by the political bodies are unconstitutional, there's nowhere else to go. That's it. It's the end of the line. So as we're talking about democracy, it seems fitting to ask the question whether or not the nature of an unreviewable decision by an unelected body of jurists seems inherently undemocratic. So why are we talking about this here when we're talking about democracy? Well, the other side of this is to ask whether or not this kind of decision-making power, which is not subject to political power, is in fact really the best way of protecting the democracy. That is, it's independent of political pressures. Along with that, of course, goes the idea that not only are justices appointed, they're appointed for life, okay? And so arguably that strengthens our democracy. Maybe another way of asking both of these questions is just to ask a pretty practical question, which is, why does anybody listen to the Supreme Court anyhow? They don't have an army. They don't have any way of enforcing it. I mean, they can issue decisions that can put somebody in jail, but they can't force the country to obey them. So why do we? And I think that what's important about that is thinking about what the Constitution sets up. By the way, it does not expressly mention power of judicial review, but the way the Constitution is set up and the way the court has operated from its beginnings. And that really is the idea of establishing an independent judiciary. And in many ways, that's the main thing that lots of countries, as they're trying to develop a democracy, will look to the United States for. That is guidance in how to establish an independent judiciary, because only with an independent judiciary can you have a safeguard for democracy. Can you prevent, as Judge Posner of the Seventh Circuit Court of Appeals said, to protect the country from the tyranny of the legislature. So let's take a look at what the court does as its actions and see whether or not, even though it's not a majority making a decision, it in fact safeguards the democracy. So that's the first part of thinking about how the court works, okay? Now what I'd like to look at is another important component of how the court works, and that is, what's the role of judicial philosophy? Probably any of you have been following the news with regard to the appointment of the 3 new justices by then President Trump. You know that the big debate is, what is the judicial philosophy of these justices? The role of judicial philosophy inherently has to play an important part, because the justices are, after all, human beings, and they come to the bench with some usually preconceived notions of how you should use the judicial power. What's very interesting about what's going on now is that there is, probably also many of you know, there is a very big split in the approach of the different justices on the court. There's a lot of minor splits, but I want to talk about 2 major ones. The first one is the idea of what is called originalism. And the 3 new Trump appointees are usually thought of as being aligned with this position. There are other justices that are already serving or have served on the court that are also aligned with this, notably the late Justice Scalia, and probably a few others that are currently on the court, typically looking at, say, Justice Thomas, and to a lesser extent, perhaps Justice Alito. But until the Trump appointees came onto the bench, they have never been a majority of the justices. So what is it that they believe? They think that the way you should construe the Constitution is by looking at what would the founders, the original drafters of the Constitution, what would they think about this problem, whatever the problem is they're trying to resolve? How would they look at this issue? Now, obviously, they realize that not everything that comes before the court today would have even been known to the founders, let alone they would have had a view about it. But their idea is to look at the text and look at the historical context of the founders and try to discern how would the founders have decided this issue. A conflicting, some would say, but certainly a different view about interpretation is what is known as a view that the Constitution is a living document. That is the idea that you can't construe the Constitution from the 18th century point of view when the Constitution was written. You have to look at it in modern times to make it relevant. And if we want our Constitution to continue to guide us and be a useful document, we have to have what's known as a living Constitution. People who support that concept have, up until recently, pretty much been a majority of the court. They've taken somewhat different approaches in the sense of how much are they going to kind of look at things totally new from the 20th, 21st century. But they have been willing to say we have to look at the context of modern times. And what that especially means is that we want to avoid problems that we see in other parts of the world. This is going to be a particularly important issue with regard to things like religion, where several of the justices have commented that we need to maintain our separation of religion and the state in order to avoid the kind of religious strife we see around the world. It's going to be critical for those who will look at rights that didn't exist at the time of the founders, if they even thought about them, things like, for example, same-sex marriage. And it's also going to look at issues that were perhaps maybe known to the founders, but really not articulated in terms of a legal view. Something like, for example, abortion. So if we look at those two views, you can see where they will often come to jurisprudential, that's fancy word for saying court conflicts in terms of how they want to resolve the issue. Another part that goes along with this idea of judicial philosophies is a criticism that is often leveled particularly against those who want a living constitution. And this is the idea that originalists will look at their counterparts and say, what you're doing is not only wrong in terms of how the founders would have looked at it, but you're kind of making up things that were never meant to be part of the Constitution. That's, they say, really judicial legislating. And we already went through why the court is not a legislative body. The answer that's given to that kind of criticism is that that is the only way that you can make general terms in the Constitution. By general terms, I mean things like equal protection or due process, which do not inherently expressly have meaning. It's only by giving those kinds of words explicit meaning that you can set forth the kind of protections and rights that need to be protected by the Constitution. So examples of that would be, what about the right to use contraception? Certainly not in the Constitution. And up until, excuse me, up until the 1960s, a number of states prohibited it. What about the right of parents to determine the education of their children, where they should go to school, how they should be educated? Again, up until the 1920s, not a right. The court read it into the concept of due process. What about the right of someone to have an abortion? Obviously, abortion was known in the 18th century, but it was not a legal matter. And many states, by the time it was the mid-20th century, prohibited it. Should it be a right? Obviously, that's one of the more controversial issues that we have today. But the court said it should be a right protected for the mother at the early stages of a pregnancy. The court will go through various different kinds of ways of finding that protection, but in essence, that right they will also find in the due process clause. So my point being that the court, some justices who believe in the living Constitution, will use these general terms to find ways to announce that certain rights are fundamental for a democracy. And if they're so fundamental for the democracy, they have to be protected by our ultimate protector, i.e., the Constitution. So this debate has been going on for quite some time. And what has happened is that now the balance of the court, jurisprudentially, by their philosophy, the balance of the court has shifted in a way that it has not done for decades. Some will call it the right. I always find it a little bit difficult to use political terminology in the court. But when I say shifting to the right, what I mean is that it's looking like those who want closer to an originalist philosophy to dominate. To the extent that you think, the population, you people on the court, think that this is not a good idea, you look to ways that you can change the unreviewable decisions of the court. So there is, for example, a concern that this rightward shift will result in undoing some of the previous Supreme Court decisions with regard to finding certain fundamental rights, like abortion, like same-sex marriage, and others besides. And so the only institution that can overturn constitutional decisions is the court itself. And they have done that. For example, you may recall in 1954, another very, very famous decision of Brown versus Board of Education. The Supreme Court overturned a case from the late 19th century called Plessy versus Ferguson. And in doing that, the court said that it is unconstitutional to have legally segregated students in public schools on the basis of race. That's overturning a prior decision. That case is a good illustration for one of the arguments that's used by having this idea of the court finding various rights that should be considered to be fundamental rights. And that is the idea that sometimes it takes a non-political body, which the court is considered to be, to make decisions for a society that either the political branches are not able to do or choose not to do. So you can probably see that that kind of argument can cut both ways. Some would argue, for example, that abortion should be a decision from the legislature. Justice Scalia was fond of saying that all the time, saying, I'm not taking a position on whether I think abortion is good or bad, but it shouldn't be decided by the court. It should be decided by the legislature. Other situations have happened with regard to the idea of same-sex marriage. Some would say, as our Sixth Circuit did before the Supreme Court decision, that that should be a decision of the legislatures and not the court. The Supreme Court would disagree with that, and Justice Kennedy would say, on the basis of equal protection and due process, the dignity of human beings to marry the person they love must be protected by our Constitution. A final thing that I want to add is really not kind of a rule of philosophy, but it's an interesting kind of sideline, and that is the idea about how much should we look to the rest of the world for what they're doing to see, are we behind the times in recognizing certain rights, or are we ahead of time in recognizing others? How should we look at foreign law? And the debate happens as to what impact acknowledging the existence of this foreign law should have in our courts. It clearly has no relevance with regard to force of law. I'm not in any way suggesting, nor do any of the justices who do look to other countries, that that has any impact on the force of making us make a certain decision in our courts. It doesn't have any precedential value. But Justice Kennedy particularly was fond of saying it's important in a modern world that we look to see what's working in the rest of the world and perhaps maybe what's not working in the rest of the world. So what you're seeing happening now, and why I think there's this clamor about the point that I'm going to discuss next, is it's time to have a change on the court. That change can be in many different forms, but the two big ones are changing the number of justices on the court and changing the idea that they get a lifetime appointment. The first one is decided by the legislature underneath the Constitution. That power is given to Congress. The second one is not something that the legislature could do because the Constitution itself gives a lifetime appointment. So to change that, you would need to have a constitutional amendment. At least most people think that. There are some people who disagree with that, but not very many. So let's see what the possibilities are with regard to that. As probably most of you know, last week, well, April 9th, it's a little bit more, President Biden appointed a commission to look at all of these kinds of issues and whether or not it was time to have some reform, and I put that in quote, depending on what your philosophy is, of the Supreme Court. The first thing I want to mention is this is not the first time that the court has done it. And in fact, it's probably fair to say that most of the time, if not all of the time, when it's done it in the past, it's done it because there's political friction in the country. There's political turmoil. There's tremendous different views about the direction of the country. So you can go back all the way to 1801, when you'll see that's the first time when the court changed the number of justices from the original 6 down to 5. By the way, just to give you an idea, the number of justices on the court have varied from a low of 5, went back up to 6 after that, but a low of 5 to a high of 10. The proposal that has been put forth by the Democrats right now is to change it to 13 by adding 4 justices to the current 9 justices. It has been 9 justices since 1869. The reason for picking the number 13, according to the statements from the Democrats, is that it's because there are 13 different circuit courts. That means the federal system is divided into kind of sections, if you will. And right now we have 13. In the past, we've had many, many fewer. But the reason for connecting a number of the justices to the number of circuits is that every circuit, regardless of how many there are, every circuit has a Supreme Court justice appointed to them to kind of represent them when there's like an emergency, like something that has to be done immediately. There's no time to go to the whole court. It's usually for an injunction. Okay, that is to prevent or to require something to be done temporarily, even if immediately. So that's their argument. Some people have argued that they're willing to try a constitutional amendment, that the answer to the issue is imposing term limits. And as I said, you will need a constitutional amendment for that. So let's kind of look at the plus minus, if you will, of expanding the court. The big reason is the one that I've already illustrated, which is people think that the court has tipped so far to the right that it's out of whack with fundamental values and, more importantly, fundamental rights. And there's a fear that some of the things that have been given in the past by the court in terms of its interpretation of equal protection and due process and the First Amendment will be taken away. But the argument against expanding the court, again, as I said to you, it's not that it would be the first time. It certainly would not be, would be that it's going to make it difficult in 2 ways. Number one, it's going to over-politicize the court. And I raised with you already the question about, is the court viewed by the people as a non-political body, and that's critical to its success as an independent judiciary. So some people would say, if you're going to try to change the number just because you don't like the decisions or you're afraid of what the decisions might be, is a political move and not necessary and a bad thing. And by the way, they argue it's going to be a slippery slope. So Party A is in power today. When Party B comes in power tomorrow, they'll add their justices to it. And it eventually will make the court unwieldy. It'll just get too large and not manageable. So is this a good approach? I'm going to leave it up to your thoughts about that, and also the Biden Commission, and see what happens with it. But that's what is going on now with this major kind of debate at looking at what is actually happening, okay, and what might happen with the court. To give you a little bit idea about whether the court needs changing, let's take a look at what the court has already done. So this is the third part that I want to take a look at, which is, let's take a look at a couple of the decisions from the court or cases that are pending. I think there's 2 areas that are perhaps most illustrative of some of the concern that people have on either side of the judicial philosophy position, and they both have to do with the First Amendment. So I'm going to really have a little bit of a focus on the First Amendment with regard to these. The First Amendment, for those of you who haven't read your Constitution in the last 5 minutes, you should know that the rights that I'm going to be talking about are the religious protections, both from the point of view of religious liberty and also with regard to the idea of separation of religion and state. The other part of the First Amendment that I'm going to talk about is free speech. And I'm going to try to talk about some controversies in all 3 of those to illustrate what may be on the line for judicial interpretation. So let's take religious liberty first. And Jackie stole my thunder a little bit by giving you the quote already from President Washington at the Touro Synagogue in 1790, perhaps the most famous presidential declaration of the importance of religious liberty. So important, by the way, that they reenact that every year at the Touro Synagogue in Newport, Rhode Island. But what exactly does it mean? The reason that President Washington wrote that letter was in response to the congregation at the Touro Synagogue, who were worried about being a minority religion in a clearly very dominant Christian nation. It was a Jewish congregation, and they wanted to have reassurance from the new president. And this is before, by the way, the adoption of the First Amendment, but after the adoption of the Constitution. They wanted really to have a reassurance from their new president of the future for their community. And so, adopting actually language that came from the congregation, he responded by this very famous quote that Jackie has given you. And it really sums up the basic notion of religious liberty in this country. I'm sure I'm stating the obvious, but we are known for our tolerance of religious liberty. And we were, even in a time in the 18th century when minority religions were certainly not as numerous and certainly not as kind of visible as they are today. But the country, because of its strong stance on religious liberty, drew immigrants from all over the world. My family came here for purposes of religious liberty. They came from a country where they saw genocide based on their religious beliefs. So I think that was and continues to be a very common reason for drawing people to our country. And I think that alone tells you how important it is, not only inside our country, but in terms of how we're viewed around the world. So religious liberty is an extremely important concept, and the court has always protected it. But it also is difficult to say you're going to protect it when it comes to the idea of separating religion and state. Again, another protection for a pluralistic society. And so you see that this is an area that draws out that distinction between the originalist and the living Constitution people, when, as I said to you, they'll argue about looking at the religious strife you see in other countries and not wanting to have it in this country. Okay, so the question becomes, how can you protect religious liberty and also ensure the separation? It's a built-in tension, and the Supreme Court has had innumerable decisions on both of those aspects. It does appear that the new justices are leaning more towards protecting religious rights, for example, allowing it to happen more with regard to giving aid to religious entities, or to allow historical monuments in the form of a religious symbol like a cross to remain on government property. It has seemingly taken greater protection of religious liberty. The statistics will show you that if you compare it from the days of the Warren Court through the Berger Court, through the Rehnquist Court, and now into the Roberts Court, that the percentage of cases winning their argument in behalf of religious liberty has dramatically increased. That's not a bad thing. I'm not suggesting that at all, but some people look at that as a concern for how will minority religions fare in this, or more importantly, perhaps, is how will that play out when there might be a tension between religious views and other non-discrimination provisions. That's another source of tension between the new justices and the old ones. You see that playing out, for example, in 3 recent cases that came from the court when all 3 justices were on the court, as temporary ways of striking down COVID restrictions. The 2 most recent ones of those in February and in April are ones in which the court said that they are not going to allow COVID restrictions placed by states, it happened to have been New York and California, when they interfere with the rights of people having religious worship. or that they treat religious worship less favorably than some secular activities like keeping grocery stores open when they're shutting down religious institutions. The very first opinion that the newest justice, Justice Barrett, signed on to was one in which it was actually not the decision of the court, but what we call concurring opinion, which she wanted to write something a little bit aside. And she took Justice Kavanaugh with her, but not Justice Gorsuch. And that is, she was willing to say it was okay to ban singing and singing inside the religious institution because of the droplets that come out of your mouth. That's why the state was banning that. But left open the idea that maybe the churches, there were churches and a synagogue, could show that that wasn't a problem. She, however, was different than Justice Gorsuch, as I just said, who wanted to strike down, along with Justice Thomas and Justice Alito, any restrictions on religious worship as long as there was any exception for secular activities. What does all that mean? It was only a temporary injunction that was issued. It went back to the courts. We don't know what the final decision will be, but it seems to be indicating what I said a moment ago, that there is much more of a willingness to protect religious liberties when they might come into conflict with other rights. Here, the rights that they came into conflict was public health regulations. You had an extremely strong dissent by the Justice Sotomayor in these cases where and Justice Kagan, when she referred to them as trying to be armchair epidemiologists. They were very offended by the idea that they would undermine the power of the state to protect other people on the basis of health. What that means, well, we don't know yet, but there is that concern. There is also concern for when there might be a conflict on the basis of religious rights with things like not wanting to provide services to same-sex marriages because those services would be a way that someone would be forced to be able to say same-sex marriage is okay when they had a religious objection to it. So there are a lot of those cases, including one that is pending right now in front of the Supreme Court, dealing with whether or not Catholic charities in Philadelphia can be denied the religious right to not place foster children in same-sex marriages. That case has not yet been decided, but it is pending in front of the court. Another issue that I want to just kind of mention is one that is not currently before the court, but has been before the court before, and that's the issue under the Free Speech Clause of hate speech. The United States is an international outlier in that we do not censor hate speech. It is protected by the First Amendment. In other countries, when I say countries, I mean democracies. In other democracies around the world, it is not legal to use hate speech. So the question in this country is, why should it be protected? The argument for protecting it is that it does harm. It's designed to silence people who are intimidated by the hate speech. It's not designed to engage in dialogue, which supposedly is the purpose of the First Amendment. And it's designed to do real harm, to cause them emotional and in some cases physical harm. The reason for protecting it under the First Amendment is that you can't make people stop hating just because you tell them they can't say things. It will just push their speech underground where you can't ever get to them and try to persuade them of the errors of their thinking. It also is looked at as a kind of safety valve, if you will, a way of letting people let off steam that may be less detrimental to society than would be allowing the speech to occur. The final thing is that I want to mention that even though we don't allow hate speech, we do allow some, I'll call them trimmings to getting rid of hate speech. Number one, the court has upheld giving enhanced penalties, that means worse penalties, if something is committed on the basis of hatred and discrimination. The other thing is that the court has shown a willingness to outlaw cross burning, which is, of course, the quintessential symbol of the Ku Klux Klan, but only if it's actually a showing of intimidation, which shouldn't be too hard a job, but it does have to be specifically shown. So what will all this mean for the future of the court? Leads me to the fourth part of my speech. And that is my conclusion. Now, I promised you a very brilliant, insightful, I'll add prescient conclusion. And here it is. The question is, what does all this mean and what lies ahead? The answer, hope you're all waiting for this. The answer is, I have no idea. Why do I say that? Well, there's not yet a sufficient record to guarantee what will happen, but perhaps more importantly is justices do not always stay the same person, the same interpreter that they were when they were put on the bench. And perhaps the best example of that would be under the Warren Court, Chief Justice Warren himself. He was the author of Brown versus Board of Education. He was appointed by President Eisenhower. He had come from being the governor of California. Eisenhower thought he was getting a conservative Republican who ended up not only individually probably being one of the most liberal justices when it came to personal rights, but leading the way ahead of the country in Brown versus Board of Education. So with that brilliant conclusion, I'll take your questions.
Amazing, amazing. Thank you, Professor Schneider, for such an illuminating talk and really just laying so many of these complicated and dynamic issues out. So clearly, we talk all the time about how you're always having to rewrite your textbooks because the precedent and the dynamics of this are changing so quickly and really quite substantially. Quickly. So there are a couple of questions in the chat. And I want to remind everyone, if you have questions you've been sitting on, feel free to enter them into the chat at the Q&A, or not the chat, I'm sorry, the Q&A function at the bottom of your screen. And I'll tick through some of these. So the first is asking about the originalists on the court and the originalist position of, as you had shared, wanting to sort of think about what the founding fathers would have intended when they wrote this or what they would have said. And so someone asks, and I think it's a fair question, we know that our founding fathers have a mixed legacy as it comes to the way we now view the way people should be treated. Some of them owned slaves, right? Some of them, obviously, gender, the way people felt about gender equality was very different back then. Many of them had those feelings, class issues. So I guess the question is the view of considering the originalist view of considering how the founding fathers would have considered an issue inherently racist or sexist, or because we are looking to consider the opinions of folks who had those biases maybe, or were living in that time.
So that's a great question, and that's one of the kind of criticisms that the originalists have gotten even before this past year, that, as I mentioned, a number of the justices have criticized their view with regard to religion, and that would lead us down the path of religious strife. And with regard to things like race, that has also been a big concern for a while. In fact, if any of you are old enough to remember Bork, who was a nominee for the Supreme Court who did not get confirmed, one of the sticking points that he had in the confirmation proceedings was because they said, okay, so you want to be an originalist and, argue against all these rights that the living constitutionalists are finding in the Constitution. How do you deal with Brown versus Board of Education? And he had no answer. There was no answer to that. So you can tell by my response of I'm very critical of the originalist argument for lots of reasons, including what the question kind of indicates of a concern for, well, maybe you want to take some of the good things from the founders, and there were plenty of good things, but you have to also remember they had problems, and you don't want to import those problems into how you look at modern day problems. Now, one of the originalists would give you this illustration, and this originalist is Justice Gorsuch. And I have to say, well, let me tell you what the issue is. Sometimes you can be an originalist, but have a question that's before the court that's not a constitutional question. That is, the issue is how do you construe certain statutes? Okay, those are not the same kind of cases that I told you about with judicial review and unreviewable. they're reviewable in the sense that if the Supreme Court interprets a statute in a way that Congress doesn't like, all they have to do is pass another statute, or an amendment, and it's gone, right? So here's the case that I want to raise to you. Last year, there was a case that came to the Supreme Court, actually in part from our own Sixth Circuit here in Cincinnati. And the issue was whether or not the phrase "because of sex," which is used in the federal law that prohibits employment discrimination, whether or not that includes discrimination on the basis of sexual orientation or sexual identity. And Justice Gorsuch, who is probably is considered one of the most conservative of these three appointees, well, I shouldn't say one of those, but certainly considered a conservative justice, wrote the opinion in which he said it does cover sexual orientation and sexual identity. So to someone who was just looking at this question of originalism, they go, what? And the answer is that he's, in addition to being an originalist, he's also a textualist, which means if he gets a case like this and he's interpreting the text, not the parameters of the Constitution, but the text, he looked at it and made an argument based on just the language of the text. Again, not the Constitution, so reviewable by Congress, okay? It meant that it had to include those other forms of discrimination. So that's one explanation I think originalists would give you, is that in some cases that aren't just interpretation of the Constitution, you might be able to find some leeway.
Interesting. Okay, next question is, in 1892, in the case of Church of the Holy Trinity versus United States, Justice Brewer stated that, you're probably going to guess, this is a Christian nation. As far as I know, this has never been expressly rejected, says the person asking this question. Any comments about that?
Yeah, I can give you a whole course in the jurisprudence of the court on religion. And suffice it to say that has been problematic for many people in this country. It has never been the modern view of many justices, but there are justices, for example, it's not quite what the question is asking, but the late Justice Scalia said it was okay for the government to show preference first, he said, for religion over non-religion. And then in a subsequent decision, by the way, he was not writing for the court, was not writing a majority opinion. In a subsequent decision, he said it was okay to show monotheism, a preference for monotheism over other religions, because he said they're protected by the free exercise clause, the religious liberty kind of thing. So it was okay. I found that very troubling, in view, not unlike what your questioner has asked. And I guess I would answer you again with those justices who have the view of the living Constitution. They're willing to say we are not the nation of the 18th century or the 19th century, but the 21st century.
Okay, so another question has to do with the politicizing the court and, keeping the court as an independent judiciary, which you shared is so important. How do we move away from a political litmus test for justices? Or
Well,
I guess first, do you think we have one? And second of all, if so, how do we move away from that?
Well, I told you I was going to give you a brilliant, insightful conclusion. It's going to be the same response to that. And actually, I wish I had a magic answer for that. But what does give me comfort, as much as I'm disturbed by that answer that I just gave you, what does give me some comfort is this is not the first time we have kind of run into this problem. And even sometimes it can be a problem for somebody who we support their views. So the last time there was an effort to increase the number of justices, it was done in 1937 by FDR, who was upset that the Supreme Court was, in his first term, was knocking down all his New Deal. And so he threatened to increase it to 15. It was not accepted by Congress. It was criticized by the justices of the Supreme Court, and he ended up backing away, but he got what he wanted. The Supreme Court started changing its mind and ultimately started upholding the New Deal. Is that possible? I don't know. But it is a big concern. And it is particularly concerned because, as I said, constitutional decisions are not reviewable other than new justices or diluting them by adding more justices.
So in terms of judicial review, there's actually a question that came in. Who calls for judicial review? Do the justices themselves call for judicial review, or is that just a sort of a privilege that they're...
It's a privilege that everyone just knows they have it. They never have to say it. Since Justice Marshall announced it, it's a given. It's never been challenged.
It goes without
Yeah,
saying.
as I said, that's not expressly found in the Constitution, which is interesting in itself. Marshall implied it from the Constitution.
Mm-hmm. Okay, another question coming in.
But by the way, that is the reason for the contentious confirmation hearings, because that's what we know happens.
Interesting. And they have been contentious. In both administrations, they've been contentious.
They'll continue.
So this question is, and by the way, this person says, so I'll read the whole thing because I think you deserve to hear the beginning here. As always, Professor Schneider has taken difficult technical topics and has made them understandable and relevant. Thanks for that. My question, a recently enacted statutory plan here in Florida will make it a felony to take part in any demonstration in which violence takes place. Under the clear words of the statute, if I am completely peaceful, but one person throws a brick into the crowd, all members of the demonstrating crowd, are subject to no release arrest and are exposed to felony prosecutions. Do you think this can withstand judicial review in light of peaceable assembly provisions?
No, I don't. I think that the court, its law dealing with incitement and participation and dealing with subversive speech and all these kinds of things that clearly came up with regard to the January 6th insurrection are not addressed by that kind of law. I think that you have a right to belong to and associate with people as long as you have not engaged in, and this is a case that actually came from Lebanon, Ohio, you have not engaged in imminent lawless activity. You have not engaged in it. And so if you join the organization with the knowledge that they're going to engage in violence and you don't refute it, you agree with it, then they could arrest you for, say, violating the peace or a bunch of different kinds of things. Subversive speech is not protected when it results in imminent violence. But if it's not because you willingly participated in that and you just happen to be standing next to the guy that throws a Molotov cocktail and you had no idea, it was a complete shock to you, you made it very clear that this is not why you're protesting, you have a right to protest. That was the difference in what we saw on January 6th. Those people are not protected by this kind of law. They have engaged in, from my point of view, they have engaged in unconstitutional incitement. The Constitution is not meant to, and this is a language that gets cited, it's not meant to be a suicide pact so that it gives you the right to destroy what it's supposed to be protecting, okay? But the idea of incitement, there is a doctrine that the court calls fighting words, and it is kind of what you think it is. You want to punch somebody in the face. But they're very, very cautious about how they use it.
So I have one other question, and then I want to ask a closing question. So there's two more, but there's really been a lot of great questions and wonderful discussion here happening in the Q&A. So that's great to see. This has to do with, can't Congress write a new law that creates a workaround that makes a constitutional decision moot, like a law to overturn Citizens United?
That's a really
good answer that in a minute and a half, you think?
That's a really good question. And Citizens United, that's been a debate since the day it came down. I think, for example, Citizens United is going to take a constitutional amendment if you want to change it. That's the short answer to that question. There have been efforts in the past where Congress has tried that, and the Supreme Court has come back with basically one of those ways, no, we're going to win that turf war. They're a little bit more articulate than my little thing, and they have won their turf war. So it's very, very difficult to see if you can find an exception, particularly even if you think you have found, a loophole in it. It's no guarantee that the Supreme Court won't close that loophole even after you've tried to do it, because remember, they have the right of judicial review.
Mm-hmm. Okay, so here comes the last one. This has to do with considering all of these moving parts and sort of so many, as you mentioned, the balance of power in the court has not changed in this way for many, many years. Some of the unprecedented things that are happening. Also, the renewed conversation since what you said the last time there was a proposal to stack the court was in the 30s, right? And it hasn't, the number hasn't been changed since sometime in the 1800s. I mean, that's a fundamental sort of unprecedented thing that's being considered, or somewhat unprecedented, not unprecedented, but rarely precedented. What keeps, as a scholar of constitutional law, what keeps you up at night?
Well, to show my bias, I worry that a number of the rights that have been articulated in the past will be eroded. If not expressly overturned, they'll be chipped away at. So I do worry about that a lot. And while I'm a very strong proponent of both protecting religious liberty and separation of religion and state, I worry about how that will play out with regard to the inherent tension with other Civil Rights Act. I think they're very difficult issues. I agonize over the idea of hate speech. And, for those of you who don't know, there is a civil suit that is suing the neo-Nazis who were the leaders in Charlottesville. So that keeps me up. So all those kinds of liberty interests and civil rights issues keep me up.
Well, many of us, for lots of different reasons, probably will be staying up with you, regardless of which side you're on. So you'll be in good company. Thank you so much to Ronna for sharing your insight and your expertise with us. It's really been an invaluable perspective, and I second what was said about how wonderfully professorial you are and how you're able to really break this down in a way that people can understand and take away so many great learnings from. So thank you so much. As for the rest of us, if you're interested in exploring more about what Jewish tradition and text have to say about today's topic, definitely keep an eye out in your inbox for a link to a recorded text study, complete with a downloadable PDF to follow along, which will be led by our JCRC's Hebrew Union College Rabbinic Fellow, Ross Levy, in conversation with Adath Israel's Rabbi Ben Chidel. And lastly, we are excited to announce that we have an all-star lineup for the rest of the series. Later this year, we're going to be joined by Yavila McCoy on August 27th. She is a pioneer really in the space of Jewish diversity work. Also really thrilled to be hosting Ambassador Dennis Ross at the Washington Institute on October 21st, and Yehuda Kurtzer of the Shalom Hartman Institute on December 10th. We will be announcing other speakers again, our annual meeting coming up in June, and we of course will be sending out more information as soon as additional confirmations are finalized. But you can always check in at www.jewishcincinnati.org/JCRC for more details as they become available. Thanks for spending your lunch hour with us, and we look forward to seeing you next time. Take care.